We will have a material emailed out to everyone that talks about, probate versus non-probate assets. It's going to come in a handout form, emailed to those of you who registered for our webinar today. Also in those materials that you'll see emailed out to you is a feedback form for any feedback that you have on today's webinar. I always like to know that. I also like to know topics that you might be interested in having an attorney talk about. So if you have any feedback on that, you're able to put that in there. Also, just so everyone knows, there is a question and answer feature today for our webinar. So I do have that question and answer feature, Q&A, pulled up on my screen. You are welcome to ask questions at any time. That is such a benefit of attending the webinar live. So you don't have to wait to the end. If you have any questions as I go, feel free to put them right in there. Otherwise, if you ever have specific questions or, as we talk about today, if there's anything that you would like to discuss with an attorney, any questions you have, we do offer 2-hour complimentary initial consultations where you can meet, again, at no charge with an attorney from our office, wherever it's most convenient for you. So as I said, Appleton, Green Bay, Oshkosh, we'll meet with you wherever is most convenient, talk about your questions in specific. Otherwise, if you have any questions as we go today, feel free to put them right there. So starting off, I wanted to kind of give just an overview of what is probate. And we'll talk about, what goes through probate and specific timelines and forms to kind of familiarize you with. But probate is really just a court process for someone's estate when they pass away. It kind of makes sure that, bills are paid and creditors are notified, and then assets go out to the, kind of heirs at law or whoever's in someone's will. And that's a really big thing too, is that wills control probate assets. So sometimes people will have like a last will and testament, and then they'll think that, they're not going to go through probate or they're not going to need a probate. And wills don't have any standing other than in the probate court process. There are a set of directions to the probate court. So if you have a will that you want to use, you want to be in probate. Probate is not a bad process. It's just typically people don't like probate for, we kind of see like three main reasons. One is probate takes some time. So there's, you'll probably hear on average probate start to finish lasting like a year to a year and a half. And if it's a contested probate, it can certainly be, a couple of years, if not longer. So because of the time and often expense and public nature of probate, sometimes people are afraid of probate or trying to avoid probate. But probate is really helpful because, as I said, it is that court process to make sure that someone's bills are paid, all of their debts are finalized, and then things kind of go out according to their wishes. Probate is not a bad place to be if you're wanting to really use your will and have your will followed. So primarily when we talk about personal representatives, I'm also talking about executors. So I'm talking about the person who is following the will, filling out the court forms, getting everything solidified. The person who is helping to see it through, that's a personal representative. And one of a personal representative's primary jobs is to make sure that bills are paid. And this creates some confusion for people sometimes because, maybe a child was a power of attorney, like a financial power of attorney during mom and dad's lifetime. And now mom and dad has passed away. Well, that power of attorney document ended when mom and dad passed. So that kid can't be paying bills and anything using that power of attorney document because powers of attorney end when someone passes. And traditionally what happens with those bank accounts is that funeral homes will notify Social Security, so that Social Security number is frozen. Families should also be notifying at least one of the major, credit report unions, TransUnion or Experian, one of those big ones, to let them know that someone has passed away. But then really all of their bank accounts are kind of frozen. So even the personal representative in the will is not able to just immediately start paying bills. So there can be typically about a 30-day waiting period between the time that someone passes and when that personal representative can actually start to pay bills. And the reason why is we need to get notice sent out. We need to get notice sent out to all the beneficiaries and really interested persons. So it's not only the beneficiaries who have to receive this notice, it's also any interested party. So someone who's like, if you disinherited a child, they have to receive this notice. Anyone who's really kind of considered that heir at law, they all have to receive notice. Because the personal representative has to be approved by the court. And typically what happens is it's like a 30-day delay, because most of the time we're not able to get all of the interested persons to sign off on the approval. So their waiver and consent forms that the interested parties, the beneficiaries, the people who would have otherwise received, consenting to the approval of that personal representative. If you get those signatures, as soon as you get those signatures and filed by the court will approve that personal representative. But typically what happens is most people aren't comfortable signing those consent and waivers. I had a client one time where their family members were saying, well, we don't want to sign it because we don't want to take on this person's debts. And that's not what you're doing. You're just consenting to this person, this personal representative or executor, taking this through the probate process, being responsible for doing those things, not that you are personally responsible for those things. But most of the time, people don't sign off on that waiver and consent, so the court will set that for hearing. If no one shows up, then that personal representative is typically approved. And then they get what is called a domiciliary letter. So the domiciliary letter is what actually allows the personal representative to collect those assets, to pay bills, to send out creditor notices. So we don't have an approved personal representative to do any of those things unless we've gotten everyone's consent or the court has approved it at that hearing. So that is most typically why there's about a 30-day delay for bill paying. So again, everyone's got to receive notice. And they're going to receive, information on the will and where things are going and have to approve that. Otherwise, once we have that waiver, we have the domiciliary letters, that personal representative can then begin, they open an estate account, they can get certain assets transferred over into that estate account, like, other previous bank accounts or investments or CDs, things like that. Then they also have to be making sure that bills are paid. So once they actually have the document giving them the authority to pay bills, they have to actually go and give what are called mail notices to all known or reasonably ascertainable creditors. So that means that if that personal representative knows or should know about any creditor, they have to mail that creditor actual notice. So they have to put something in the mail saying that, okay, this is the deadline the court has set for when you have to have all claims filed by. And then for, any unknown creditors or creditors that personal representative doesn't have a duty to notify, that's where we do a publication of notice. So that's why if you look at newspapers, most frequently in Appleton, we publish that kind of in the Post Crescent. If you look at the Post Crescent and you see something like so-and-so has a probate estate and it's 2023 or 23 PR, whatever the case number is, then it kind of shows creditors until what point can they file a claim. And, credit card companies, major creditors are always checking these things to make sure that they don't miss any dates to file a claim. But what's really helpful about this process is that if a creditor misses that date, you don't have to pay them. Like your personal representative actually has a duty to, I think it's like optimize your estate or maximize the estate. So the personal representative, if that creditor comes forward after the date the court has set, you don't have to pay them. And this is a really good point for probate. There are very specific reasons why you would want to go through probate. So I know a lot of times we'll talk about, what doesn't go through probate. But if you have a deficit estate, or if your family member has a deficit estate, meaning that it's like their estate filing bankruptcy, they owe more money than they have, the exact place you want to be is probate, because a probate court judge is going to set that date. And even if no one in the family actually gets money, Well, at least they don't get those liabilities either, because there's that set court process. All creditors are finalized. You know, the court decides who gets paid, and then it's kind of done. So at least you're not assuming any personal liability. So probate does very much have this idea of, you know, if someone passes, you file the will, you try to get everyone's consent. Otherwise, you basically set it for hearing. The personal representative is approved. They can go ahead and set these notices out to known creditors. They publish these notices. Typically, I think it's like 3 months, like 90 days that the court will set for creditors to come forward. If they don't come forward after that, the estate can pretty much, you know, they'll do accounting, they'll file taxes, and then everything will be completed according to the will. So typically that's why it takes your year to a year and a half to complete. It's not because your personal representative isn't doing what they're supposed to do. It's because this is a court process, and it can kind of feel at times like an idea of hurry up and wait. Like, you do what the court tells you to do, and then the court will get back to you with the next thing you need to do. It's not a bad process. You just have to be aware that it does take time. And that there are specific things that you have to do in the right order to make sure that everything goes the way it was supposed to. Now, what actually goes through probate? Because then this is a really common problem too, where people are trying to avoid probate. So they pass everything through like ownership or beneficiary designation. So we only get things through probate, through the wills, if there's no joint owner on something, or if there's no beneficiary designation on something, or if the beneficiary designation is to that person's estate. Because, for example, retirement accounts, 401ks, IRAs, if those things have beneficiary designations, that avoids probate. It's like a point A to point B transfer. It's just moved directly to those people's names. Same thing with life insurance if it has beneficiary designations, or if your bank accounts have pay on death designations. Or if a child is on as an owner on an account, then when mom or dad passes, it just becomes that child's account. So sometimes I see where people have beneficiary designations on everything except the house. So then we'll have the house going through probate and no assets to actually pay for it. So again, you will bypass probate if you have documentation like beneficiary designations in place that just send those monies out. And then the problem is that it will just do exactly that. It'll send the money right out to those people. And if you have planning in your will that you wanted, well, your will is a very nice piece of paper, but it doesn't really do anything for you if all of the assets are outside of the probate process. So this can get very messy for a personal representative when there's some things that went through probate and some things that didn't go through probate, or if everything just went outside of probate and now there's no money to pay bills. Bill paying can be big problems, and also trying to make sure that things really got where you wanted them to go. So probate is not a bad process because it guarantees that result. So if you want to use your will, you should want things to go through probate. If you don't want to use probate, or you like the planning that your will has, then it's just really important that you talk with an attorney about how to coordinate those things, just so that way it's working the way you expect it to. Lots of people don't realize that the will controls what goes through probate, and beneficiary designations avoid probate. And then they're confused and concerned about what probate actually does and how long it takes. So I hope that kind of clarifies, again, just some of those really common things that every personal representative or executor should know. Again, if you have any questions, you're always welcome to put that in the question and answer, and I'm happy to answer those things as we go. Otherwise, a couple other things that you should know about probate. I guess I'll talk a little bit about contested probates. I have alluded to this a little bit. Sometimes people can contest the will. They can say that, you know, mom or dad didn't have capacity at the time, or someone was unduly influencing them. If it's a contested probate, this can take a lot more time than that year to year and a half that I said. So oftentimes, if someone is disinheriting someone, that might be a reason, or they think that something might be contested. They might want more privacy. That's not sometimes a place where we want to be in probate for. So if you're disinheriting someone, it may be a reason to look at doing something other than probate. because then they don't have to get those same notices. If you like the idea of a judge, like the reasons I really would use probate would be if you have specific planning in your will that you want. So if you have supplemental needs trust or specific restrictions or asset protection or planning that you have in your will that you want to be followed, you want to make sure you're using probate. So if you have specific planning, oftentimes I do specific planning for spouses with long-term care concerns. So there's planning that we can do to protect the assets of what's called the community spouse for Medicaid in case they pass away before the spouse who's receiving care. We do that planning in wills all the time. That's a really important and powerful tool. If someone has a deficit estate, you absolutely want to be going through probate. If someone has minor children and you're trying to nominate guardians, which is who kind of takes over custody for those kids, you would absolutely want to be going through probate. Sometimes people are trying to avoid probate just because they're confused about the time and expense and other things that happens. And typically then we're doing something else. We're doing some sort of combination of beneficiary designations or looking more at like trusts, which our topic today is not about trusts, but I just kind of want to explain again sometimes why people are afraid of probate and then what other tools they're using. But if you have the will and you want to be going through probate, what you should make sure is that you don't have anyone else as the owner on the account and that the beneficiary designation is actually the estate, or it doesn't have a beneficiary designation at all. Because again, it will pass outside of probate and directly to those people if you have those beneficiary designations. So I apologize. I feel like I've got through everything really fast. I guess I was kind of expecting people were going to have more questions, but that's okay. I guess that just means that I covered really all the important things that everybody should know. So again, if you have any questions, you're welcome to put them in chat. Otherwise, we do offer those complimentary initial consultations. Next week, for next week's webinar, we're going to be talking a little bit more about Medicaid. So I know I alluded to long-term care planning. Next week, we're going to be talking about signing your home over to your kids and other risky Medicaid tips to try to avoid. So that's a really big one where we're trying to maintain some tax positive things and good control things. So we'll be talking a little bit more about long-term care this time next week. Otherwise, we have a really good wills versus trust seminar. So if you want, if you learned a little bit about probate or you have more questions on probate, or you want to hear a little bit more about trust, we actually talk about, we have a whole, wills, trust, foundational course that we do. That's going to be on March 13th, and we're actually going to be at the DJ Bordini Center here in Appleton. So we do a 2 o'clock and a 6 o'clock. And you can always go to estateplanninglive.com to see our full schedule of webinars and public seminars and register for any of those things if you'd like to attend or have other questions. So otherwise, I won't keep talking if I'm kind of out of things to talk about. So thank you all for your time, for attending. And if you have any specific questions or want to attend events in the future, just let us know. Otherwise, have a good rest of your afternoon.